The Specter of Communism in Hawaii, 1947 to 1953. Appendix A. Defense Exhibit H and Evidence. Principles Circular No. 943. Department of Public Instruction, Territory of Hawaii, Honolulu, March 16, 1948. To all principles, zeal for American democracy, the professional obligation of the teacher to remain neutral on controversial issues, to present impartially the facts and arguments on both sides of any question, may result in some uncertainty on the subject of communism. Such uncertainty, if it exists, is no doubt increased by the confusion deliberately fostered by communists. The propaganda that teachers are threatened with gag rule, that fear has silenced them, is in itself a crafty suggestion that they need to be afraid. The fact that some states recognize a political party called communist may give rise to some honest doubts. Teachers have shown a commendable disposition to suspend judgment, where individual loyalties have been questioned, until the facts are in and the evidence heard, but this virtue can easily be exploited by subversive forces. It is a simple trick to interpret silence as a sign of timidity, and finally the very devotion of teachers to the cause of civil liberties may disarm them for the encounter with communism unless clear thinking and full discussion prevail. Two distinctions need to be made sharp and clear to dispel any such confusion. First, we must differentiate positively between the appropriate attitude of the teacher toward controversial issues in general, and the role of the teacher with respect to communism. Then we need to contrast boldly the principles of American democracy with the cunning strategy of the Communist Party. The seriousness of the problem is clear enough and becoming clearer every day. The magazines are full of it. Press, radio, and official reports have brought it into sharp focus. The tragedy of Czechoslovakia may be due for reenactment in Italy. Then France may be next. It can't happen here, we hope, but if not, it will be because we stop it now. Current events in Europe show the pattern of intimidation, fraud, and terror by which free countries are taken over. The discrimination we need here will depend upon sober judgment, not emotional propaganda. A brief review of the contrast and conflict between communism and American democracy may lead to a profitable exchange of ideas concerning the problem. The communism we are talking about is not just another political party. It is a dictatorship which demands unswerving loyalty and uncritical obedience. As a philosophy of life and a system of government, it is the very antithesis of democracy. It places little value on human personality. The individual is of no importance except as a servant of the state, to be liquidated for the slightest deviation from the party line. It holds that the end justifies the means and teaches its devotees the black arts of deceit, falsehood, and violence as a means to power. It abuses the moral principles and civil liberties of free peoples in order to destroy those principles and abolish those liberties. It tolerates no disagreement, no freedom of thought or action, and crushes all opposition. We cannot afford to compromise nor to temporize with such a system. It does not present a debatable question which has two sides for good Americans, for it would destroy the very possibility of effective difference of opinion on all other issues. And yet our defense against it is not the method of the secret police and the firing squad. Our defense is education. It is our responsibility to lead youth to an understanding of how our freedom depends upon constitutional government, what the alternative of tyranny under absolute power would be like, and what duties and responsibilities we have as citizens of a democracy. We have inherited a system and a tradition of holding our representatives responsible to the will of the majority and of respecting the rights of minorities. We place supreme value on individual human personality and make the state subservient to that end. We guarantee protection for the individual against arbitrary use of official authority. All of this we stand to lose if we fail in our educational task. These values we have taken for granted, possibly because the threat of their destruction never before has been so great. If they are understood, especially by our young people, if democracy is made to work effectively, we have little to fear from communism in our country. But to allow communism to grow by granting it the status of any other controversial issue, feeding on ignorance and injustice, is blindness indeed. Free speech and majority rule are characteristics of democracy, not of communism. If he who would destroy free speech claims it as a right, we would do well to remember that liberalism is not called upon to commit suicide in the name of consistency. To carry freedom to the point of self-destruction is absurd. Under our machinery for orderly and peaceful change, there is room for wide divergence of opinion. Both the liberal and the conservative, the radical and the reactionary, are free to win support for their ideas by the method of open discussion and persuasion. When a sharp line has been drawn between this procedure and the practices of totalitarianism, whether of the right or the left, then both the conservative and the left-wing liberal are in a stronger position. Unless this distinction is drawn, anyone of liberal ideas is apt to be called a communist. The labor movement offers a good example of this tendency. Some who are opposed to labor unions in general condemn communism and organized labor in the same breath. In doing so, they take in too much territory. For workers to join unions and employ concerted action to improve their incomes and conditions of work is perfectly legitimate. But the unions themselves, if they are smart, will throw out the communists. If they fail to do so, they center upon themselves and their legitimate union activities all of the opposition to communism. A wise teacher, in the discussion of any controversial issue, will not use his position nor his classroom to spread propaganda for either side. He will present the facts, help with the analysis, and submerge any personal prejudices he may have. He will indulge in only one kind of indoctrination, namely, the use of the democratic method of resolving such conflicts. However, where the question of communism is concerned, such academic impartiality is a sign of uncritical thinking. There is no middle ground on this issue. What more can we do about the challenge and threat of communism? How can we combat it without violating our own principles of political freedom? We can read about the problems involved, discuss them with our co-workers, and unify our thinking concerning them. An excellent starting point is the special issue of School Life for February 1948, from which the title of this circular is borrowed. United States Commissioner of Education, John W. Studebaker, in the leading article quotes J. Edgar Hoover on a number of don'ts to remember in the fight against communism, and then adds a number of positive admonitions of his own. Don't confuse liberals and progressives with communists. Don't fail to make democracy work, with equal opportunity and the fullest enjoyment of every American's right to life, liberty, and the pursuit of happiness. Do give young people a clear understanding of the essential elements of the American democratic way of life. Do contrast very concretely the philosophy and practices of democracy with those of dictatorship. Do help young people to recognize the elements of communist strategy and to be intelligent and skillful in thwarting that strategy. We can all cooperate in the national program for Zeal for American Democracy by reading the articles in that magazine and discussing them in teachers' meetings. Let us know in the central office what you and your staff think of them. We shall also welcome the reaction of principals and teachers to this statement, including any criticism or any suggestion for modification or extension of it. Very truly yours, W.H.L. ed. Signed W. H. Loper, Superintendent. Appendix B, Annual Letter, 1555 Pi Ikoa Street, Honolulu 21, Hawaii, December 26, 1947. Greetings. Last New Year, we did not write to you because we were taking a vacation on Maui, and most of you had already received Aiko's letter about the sugar strike. This New Year, we shall return to our annual custom, though we are on trial for our lives. Do not be alarmed, it is only our economic and professional lives. We are suspended from our positions on charges of membership in a secret, underground society, namely the Communist Party of Hawaii, and of all the odious and disreputable consequences of such membership. To give the background of what the newspapers are headlining as the Reineki case, we must discuss pretty much all the economic and political developments of the past 2 years. So sit and read patiently. The ILWU-CIO grew rapidly all through 1944 and 1945 and most of 1946. It brought all sorts of benefits to its members, including the standardization of wage rates and job classification, $1.5 million in overtime pay, relief from petty oppression by managers and foremen, and a spirit of freedom in plantation life. It also threw its weight around in the 1944 elections. However, the employers, the famous but misnamed Big Five, the big one, really, looked upon it with apprehensive eyes. The ILWU offered them the hand of friendship, but they refused to shake it. The Hawaii Employers' Council, which assumed the negotiation of all labor contracts, became more and more an instrument for stalling negotiations and fighting unions in a gentlemanly, underhanded way. We give not our own opinion but that of an NLRB trial examiner. The result was the sugar strike of September 1 to November 14, 1946. Aiko described it in a letter which most of you have read. If you did not receive a copy and would like one, please let us know. The union won cash gains averaging about 20 cents an hour, had the century-old, dependence breeding perquisite system abolished, and cash paid in lieu of the perquisites, and brought a great feeling of independence and manliness. During the strike, all the waivers joined the union. It was a frightening victory, all the more so because of the success of CIOPAC. The progressive wing of the AFL had parted company with the ILWU, and no real effort was made to bring in citizens not in unions. Yet PAC showed itself stronger than in 1944. This was in spite of a burst of red baiting such as accompanied the elections on the mainland. To vote Republican was to vote for the only truly American party. One Republican candidate went about Jew baiting, since 3 of the ILWU leaders here during the strike had German names, and boasting how he would run these men out of the islands. Meanwhile, the semi-fascist advertiser carried cartoons of 3 repulsive, hook-nosed carpetbaggers raking in union dues. The advertiser was full of hysterical letters, the most hysterical being one written by blue-blooded S.N. Castle, member of several learned societies. How long are we to be dupes, to supinely let a set of saboteurs ignore or ridicule our courts, defying our laws though claiming their protection? The mask slips slightly and reveals the face of Moscow. Uncle Joe says, vote for PACCIO endorsed candidates. Are we to live free, or are we going to be content to become the slaves of Moscow? The issue is joined, I say and I say again. No American can afford to vote for any candidate endorsed by PACCIO. The issue was somewhat confused by PAC's refusal to go all out for the Democratic Party. Joseph Farrington, delegate to Congress, see the cover of Time, December 22nd, is publisher of the largest daily. For Hawaii, he is something of a liberal. He is a persistent and effective fighter for statehood, which is the ILWU's great goal also. The whole business community was for statehood then, publicly. Today some of the most important men are openly against it, mingling Jap and Red in their arguments. PAC, with one eye on statehood and the other on the neutrality of the Star Bulletin during the strike, endorsed Farrington over William Borthwick, Democrat, the candidate of Governor Ingram M. Steinbach. Had PAC endorsed Borthwick, we might be writing a very different letter. For the governor, who comes from the state of Senator McKellar, has some of McKellar's stubborn vindictiveness in him. By the end of the strike, which coincided with the close of the elections, Steinbach and the ILWU were bitter political enemies. The governor demanded Jack Hall's resignation from the Honolulu Police Commission, to which he had appointed him, on the grounds that Jack had written a scathing open letter against an injunction granting Judge. Jack replied with, "Everyone knows the real reason that I did not support Borthwick." Within the Union, too, there was some dissension over the endorsement of Farrington, because the Democratic Party is traditionally the poor man's party. In the case of one Unionist, this dissension, as you will see, has had serious results. Farrington was re-elected, though the Hales of the Silk-Stocking precinct scratched the Republican ticket for the first time in history and voted for Borthwick. Elected also, by a margin of 16 votes, was 72-year-old Johnny Wilson, the Democratic mayoralty candidate, even though Merchant Street poured money freely in support of its own blue-blooded son, Monty Richards. Wilson is a great fighter, and today he is on the worst possible terms with the governor because the latter, it appears, brought about the miscarriage of a drive to clean up the police force, which had taken bribes wholesale from the brothels. Elected to the Honolulu Board of Supervisors was John's former student, a strong labor man named Kejama. Moscow's kiss of death did not frighten the voters as it did Castle, but neither was PAC strong enough to overcome the old practice of voting for personal and racial reasons. The score, a clean sweep of Maui County's Board of Supervisors. Control in Kauai County, 8 Republicans and 7 Democratic senators, nearly all of them conservatives, 16 Republican and 14 Democratic representatives. Then a Republican from West Hawaii died. Both parties threw all they had into the by-election. The Democrats won by a small margin. Score, 15-15. Consequences, an 18-day deadlock in organizing the House, which was ended when a PAC endorsed sold out. No legislation of importance, good or bad, passed. Deepened apprehension on the part of the Big Five. And Roy A. Vidosek, brains of the Republican Party, died of heart failure during the session. This seems a very discursive way of getting to the suspension of the Reinekis. But have patience. The Communist Party has no monopoly on fronts. During the sugar strike, a new program was put on the air, at first under the auspices of the Elks, called Spearhead for Americanism. Its later means of support are not visible. It followed the approved pattern. First, a series of broadcasts on the horrors of Russian communism, adapted from material supplied by a fascist organization, dumbed down and presented in the tradition of ham melodrama by a vulgar little announcer who by now fancies himself the chief savior of Americanism. Next, the ILWU-CIO was indicated as the local agent of Moscow. Finally, everything displeasing to Merchant Street was smeared with red, a Territorial Fair Employment Practices Act pushed by the Hawaii Association for Civic Unity, a proposed medical insurance bill, not even supported by the unions, a Milk and Water Consumers Council worrying over high prices. All this in broadcasts that literally turned the stomachs of intelligent folk. But effective. In March 1947, the Pearl Harbor reports were published, which contained photostats of charts compiled by the FBI before June 1941. These charts showed agents, sympathizers, and fellow travelers of the Axis powers and communists. However, the quality of the FBI's sleuthing is evidenced by two entries. A judge who was recommended to the Territorial Supreme Court was listed as a German sympathizer because he belonged to the Anthroposophy Society, and a Jewish man was on two lists of sympathizers, the German and the Communist. Despite its absurdities, the Communist chart was accepted as gospel by many and was cited by the governor as evidence of known and proven communists. John began to be mentioned as a person to be purged from the school system. Although the sugar strike was a great defeat for the Employers' Council, they were resolved to retrieve it in the approaching showdown in the pineapple industry. They drew out negotiations and protested how unreasonable the ILWU leadership was. Meanwhile, the spearhead prodded at the Reds, but the ILWU scorned counter-propaganda. By the 1st of July, the ILWU found itself in such a position that a work stoppage was inevitable. The employers called it a strike, while the union called it a lockout. Whichever it was, it lasted only 5 days, and the union went back to work practically on the employer's terms. In all reason, the ILWU should have suffered a great defeat. The plantation hands were militant, but not the Honolulu cannery workers, and there were plenty of strikebreakers. High school kids wanted jobs during the vacation, and public sentiment was against a strike. The pineapple units went out almost criminally unprepared. The president of the pineapple local was a drunken, incompetent, and dishonest fellow who had been thrown out only a few weeks before and was going about red baiting and trying to split the workers. Mass picketing was quickly enjoined by the courts, and the police dug riot sticks into pickets' stomachs and escorted scabs through the lines. Yet today, the morale of the pineapple workers is stronger, and their understanding of unionism is better than it was before their defeat. The treatment they got from the police might have been specially ordered straight out of the opening pages of State and Revolution. Harry Bridges and Bob Robertson explained the reasons for the defeat so clearly to the key Unionists that it became to them only a single battle lost. Straight away, both sides began preparing for a grand showdown in February or March of 1948, when contracts of all three main industries, pineapples, sugar, longshoring, would be reopened for wage adjustments. The ILWU leaders, who had spent too much time at their desks, went from plantation to plantation, explaining the situation and trying to get the shop steward system really functioning. It's important to remember that the ILWU, with 35,000 members, has few who really understand unionism, and the leadership has not yet succeeded in integrating the social life of the plantations into union activities, so meetings are poorly attended. The employer's strategy was, and is, simple: talk about irresponsible Reds, and Reds who preach class hatred, and then talk still more about Reds. Some of the Catholic clergy are helping them at the job. As we said before, the governor was in an anger with the ILWU for not going along with him at election time. The ILWU reciprocated heartily and pressed the Department of the Interior and the Democratic National Committee to have Steinbach removed. The times being propitious, praise be to St. Thomas, the governor began assailing the ILWU for its Red leadership, each time more specifically. Just what the tie-up between the governor and the employers in this campaign may be, we do not know. But we do know that an expert was sent from California to guide the employers' part of it. Finally, on Armistice Day, Steinbach read an excerpt from what he claimed was the plan under which the Communist Party of Hawaii had been operating for years, and which had been written by someone later identified as John, and he promised to see that all communists were cleared out of government service. Now we must go back and tell about Edward Berman and Akiro Izuka. Berman is a tall, strongly built, sallow man who seems always to have a dissatisfied sneer on his face. He led the 1938 Inter-Island strike and then went to San Francisco to work as a longshoreman and study law. Coming back to Hawaii with a law degree, he evidently expected to be taken up by the ILWU as legal advisor and one of the top leaders. But his reputation from San Francisco was so unfavorable that he was cold-shouldered from the start. So he began trying to win individual followers from the union ranks. Once he stopped John in the street and began with this subtle approach: Jack Kawano and McElrath have no use for you because you are an intellectual. They say, comes the revolution, Rioneki will run like a rabbit, pissing his pants at every step. But there is a place for us intellectuals. Don't you agree? I can work all day on the waterfront and then write a pamphlet. Can Kawano do that? Berman hooked one follower, Izuka. Izuka had eaten enough bitterness to know better. He had gone through a 10-month strike and had spent 6 months in jail and concentration camp early in the war, sent there by a board of plantation managers. But, from what we gather, he felt that the ILWU was not using his ability, and for that reason he was resentful toward Hall and Kawano. Berman became friendly with Borthwick and the governor. He pinned great hopes on Borthwick's election. Some think he expected to be appointed his secretary. He and Izuka campaigned strongly for Borthwick and began denouncing the leadership of the ILWU. Immediately after the Armistice Day speech appeared a pamphlet, bearing Izuka's name as author but written in excellent English, The Truth About Communism in Hawaii, named as Communists Hall, the McElraths, Kawano, and about 25 other unionists of various ranks, and as many other persons, including the Reinekis. This pamphlet has been sold and given away wholesale by employers. The Hawaii Government Employees Association, which is losing members to the United Public Workers CIO, and AFL leaders. Here, like Herodotus in his time, your historians must make another digression. The coolness that began over PAC tactics between the ILWU and the Rutledge wing of the AFL developed into an open split because of rivalry in organizing, and by the end of 1946, the breach between the leaders was unbridgeable. This was a great grief to John, who withdrew from contact with the AFL unions so as to avoid being caught in the fight. His work with the electrical workers is one of his most pleasant memories, and for all Rutledge's present red baiting, he cannot help having a personal aloha for irrepressible art. The Izuka pamphlet has had great effect within the ILWU. How can anyone who has not been systematically educated to the reasons for red baiting avoid feeling uneasy at the word communist? A number of leaders have been in the ILWU from the start, not so much because of devotion to the working class as for political and other personal reasons. One of these is Rep. Amos Ignacio of Hawaii Island. Animosity between him and another Hawaii leader almost wrecked PAC there in 1946. Without warning, on December 14th, Ignacio and several other sugar unit officers formed a new union of Hawaiian workers, claiming 4,000 members. This union was immediately received with plaudits by employers, politicians, and the press. But already, thanks to very energetic propaganda by ILWU people, it appears that most of the rank and file have repudiated the union to which Ignacio claims they belong. Still, even if Ignacio's UHW is only a paper union, it can have lots of nuisance value. Every splitting device, race, religion, the mainland carpetbagger argument, and of course the menace of communism, will be used to the full in the next few months. When he read the Armistice Day speech, John knew he would be the first marked for the slaughter. By his long activity in the labor movement, he has become a sort of symbol of the intellectual turned traitor to the class on which he should depend. Of recent months, he has done nothing to make himself less conspicuous, for he was called as an expert witness in 2 cases which challenged the established order in Hawaii. One was a suit brought by Chinese schools to challenge the constitutionality of the Wartime Act that virtually closed foreign language schools. A whole array of experts and big names in local education appeared on behalf of the territory. John was the sole expert appearing for the schools, but the case was argued by L. Wirren, attorney for the American Civil Liberties Union. A panel of 3 federal judges found the law unconstitutional. The other was the Maui County grand jury case. The grand jury had indicted some pineapple strikers for throwing 2 foremen into a harbor. The ILWU attorneys, who had been giving local courts a bad time, letting workers know they have legal rights, challenged the constitutionality of the indictment because the jury was not a cross-section of Maui chosen at random but was highly selective on racial and class lines. Grand juries for years have been drawn preponderantly from the small white minority. Most of the statistical preparation for this case was done by Harry Oshima, an economics professor revisiting his native Hawaii, but John also appeared as a witness. The grand jury foreman is also a commissioner of public instruction. ACO has been prominent too. When Art Rutledge threatened a strike of all the public utilities in the summer of 1946, suddenly there sprang into existence an organization called We, the Women of Hawaii. Carried away by their own hysteria, these cultured women almost tore poor Art limb from limb. A second meeting was called to organize the group formally and elect officers. Obviously, this was intended to be another pressure group dedicated to the fifth freedom, the right to work unmolested by unions. A little group of women in the ILWU circle went to the meeting and began asking what the purposes of We, the Women, were. So flustered were the leaders that it took them several months to get their breath, and then they organized on innocuous community benefit lines. Speak of class hatred, you should have heard the way these upper-class women jeered and booed the labor spokesmen, ACO among them. Mrs. Ruth E. Black, another of the commissioners, was the author of the Fifth Freedom phrase and a main speaker. She is the one who tried to have John fired last spring when she took offense at his putting a summary of the Hartley Bill on his blackboard. ACO also attempted, unsuccessfully, the organization of a small Japanese-owned department store for the UOPWACIO. 2 girls were fired because they came to our home to talk about unions. Both of us showed our solidarity with the sugar strikers. We visited the strikers at Lahaina, where the strike was prolonged almost till New Year because the manager, in violation of the new contract, fired several men who had beaten overseers who tried to irrigate cane. ACO, as she told you in her letter, helped lead the women's demonstration at Kaloa on Kauai, which demanded that the plantation release the rice it was hoarding. and both of us went on the picket line during the pineapple strike. We went down to the canneries the first morning planning to be observers. But how could we stay out? John went to the district where he teaches and saw his graduates among the crowd, a colleague of his scabbing, and the picket line weep. Soon he was the most vociferous person in the line. Aiko at the entrance to another cannery saw women bystanders undecided. She gave them a pet talk urging them to join the picket line and ended by setting an example herself. And believe us, we would not have missed that experience and solidarity for anything. So, to return once again to our case, we were not surprised at being made the first victims of the governor's crusade. On November 25th, we were suspended without pay, pending trial before the Board of Commissioners on December 18th. The governor at that time promised to make a sweep of communist sympathizers as well as of party members. Later, perhaps because his threat sounded too much like thought control for people to stomach, he confined himself to card-holding members. He has been making a great to-do demanding that the Reineckies answer, in advance of the hearing, yes or no, are they enrolled communists? Naturally, given the nature of the charges against us, we are answering in our own way at the proper time. Meanwhile, the governor's vociferations plus the Izuka pamphlet have convinced a great many people that we are indeed party members, therefore traitors. But many others realize that the governor is motivated less by love of country than by personal pique at the ILWU, and he did nothing to strengthen his case by saying that we territorial employees are to be an example in order to force the ILWU to repudiate its leaders. After all, people wonder, how did the Reineckies manage to teach for 20 years and gain a high reputation as teachers if they are as bad as Steinbach says? But then our supporters, according to the governor, are all communist sympathizers or misguided fools. The charges set forth allege that we are members of a secret, underground society existing unlawfully without license in contravention of a law passed in 1884 to put down Chinese tongs. It is further alleged that the Communist Party of Hawaii must obey the orders of the Communist Party USA, which in turn follows a party line beneficial to the Communist Party of the Soviet Union. The principles of these parties are said to be the antithesis of and opposed to the principles of democracy. The secret society is claimed to be undemocratic in structure, demanding blind obedience to its orders and engaging in highly dishonorable and reprehensible activities. It is alleged that our membership has been exposed and publicized in the community, thus bringing us into disrepute. The charges claim that we are not possessed of the ideals of democracy, and that by reason of our membership, we do not bear undivided allegiance to the government of the United States. John is accused of being fanatically devoted to the Soviet way of life. Finally, it is stated that if we are permitted to continue in our positions, it will bring great odium and disrepute upon the DPI, so we must be relieved of jobs and certificates. These charges were drafted at the governor's orders by the current Attorney General and signed at the governor's orders by Dr. Loper, the Superintendent of Public Instruction. Our attorneys, Harriet Bauslag and Meyer Simmons, went into federal court to ask for an injunction against the board hearing, citing that our constitutional rights were being invaded. As soon as the Attorney General caught wind of their intention, he struck out the charge that the secret society exists in contravention of the law. We had already issued a statement to the press asking why we hadn't been indicted and tried in court if we were lawbreakers. 2 days before the trial was to have been held, Judge Delbert E. Metzger granted a temporary injunction, which lasts until 2 more federal judges arrive on January 7th to sit with Metzger to decide the Maui grand jury case. The panel will decide whether to grant a permanent injunction or to remand the case to the board. This breathing spell was a great upset to the governor's plans and an equal encouragement to us. Meanwhile, a Hawaii Civil Liberties Committee has been organized to coordinate defense activities and handle funds. Petitions with 1380 signatures have already been turned in, demanding our reinstatement, and we hope to triple the number, despite the fear of many persons that they will lose their jobs, or something terrible, if they sign. Most effective have been the letters that have been published, written by persons who know us. We are also lining up character witnesses. If any of you know us fairly well and wish to be of help, you may write a letter in duplicate, addressed to the Commissioners of Public Instruction, Territory of Hawaii, and send it to us for presentation at the hearing. If it is short, send it in triplicate so that 1 copy can go to the Star Bulletin. You can tell when you knew us and under what circumstances and what you know of our general character, of our possession of the ideals of democracy, and of our loyalty to our government. Add enough about yourself to show that you speak with authority. This crisis is an education for us in people's behavior. Most middle-class people, and teachers most of all, are terribly frightened of the word communist. Working-class people don't care nearly as much. They figure that the Big Five must have a finger in this affair. On the one hand, we and our supporters have received abusive anonymous letters, and on the other, strangers have stopped us on the streets to wish us well. One teacher whom we have known for 16 years and who was John's colleague for 9 was too frightened to allow us to come to his house to discuss the case. Another teacher who had met John twice put his name to the advertisement of the first meeting of the Civil Liberties Committee and is working heart and soul for it because it made me so damned mad to see teachers so cowardly. John's principal, Walton Gordon, immediately the case broke, issued a warm statement praising his teaching, which was of great help, and he will appear as a witness for John. Aiko's principal, Stanley Miyamoto, her high school mate, our personal friend, and co-worker in liberal activities for several years, on the other hand, is doing a sort of Louis Budence. When Aiko was suspended, he refused even to testify on her behalf. He has promised instead to testify for the Attorney General. Last summer he raided Kravchenko and Budence and got the red horrors. Perhaps, too, he fears that he is one of the 6 teachers mentioned for investigation. Everything else about this affair has made Aiko fighting mad, but Miyamoto's attitude was a terrible shock. If some people whom we thought friends have fallen away, those who are standing with us are the most precious, and they are many. We have come to appreciate, with humility, the integrity and goodness of people as we have never done before. Among them all, we must give special places to our attorneys, Mrs. Bauslag and Mr. Simmons. They are resourceful, courageous, and understanding. Without them, we would be up against it. The most gratifying part of the Rienecki case, personally, is the knowledge that our teaching has been appreciated. John was told, with some exaggeration, doubtless, that Aiko is regarded as a saint by Whaley parents. One of these parents, a widower with 6 little children for whom Aiko has done a few small favors, got 83 signatures to a petition and wrote a glowing letter in her behalf. Another father declared, "I don't care what you are my friends. I'll testify for Mrs. Rienecki even if it meant going to jail." All of John's students are demanding his reinstatement. Several are going to testify for him, and others have circulated petitions in spite of mild intimidation by the Attorney General's office. Several alumni are also testifying and scores are circulating and signing petitions. Even if we should lose our jobs, we shall go with the knowledge that people think we have done well in our profession. But we must not lose. We must stop this witch hunting before it can spread. Our family, too, is backing us loyally. After 10 years at 3571 Pahoa, we left our rented house. The landlord's son had been paying $95 a month rent for a small apartment and claimed his rights as part owner. Now we are living comfortably in one wing of a great old termite-eaten house of Aiko's parents. Lucky for us, too. Her brother and sister and their small children often come in and help keep us the good thing we find it to be. Forgive us that in our haste we have not acknowledged your news of marriages, of children born, and the other good things in your lives. But we rejoice in your good and wish we could see each of you again. Salud. A. John and Aiko. Appendix C. What Must We Do? By John E. Rienecki, Honoka'a, Hawaii, c. June 1935. 1. The great, ultimate aim of all activity must be the organization of workers in the sugar-cane and pineapple industries into militant industrial unions, whose aim shall be the domination of those industries. Immediate objectives shall be set up to fight for, but must not be allowed to obscure the true aim of the unions, domination by labor of the basic industries of Hawaii. Immediate objectives can best be determined by the circumstances, but would undoubtedly include the 8-hour day and 44-hour week, with time and a half or at least time and a third for overtime, wages to be raised above the present subsistence level, extra pay for those not provided for gratis with lodging and perquisites, rapid improvement of housing and related conditions on the plantations, abolition of racial distinctions in assigning of living quarters, abolition of racial discrimination in assigning jobs, legal recognition of unions and of their functions in helping determine policies on the plantation through committees and secretaries, somewhat on the Mexican model, fair treatment of small contractors, and remedy of exploitation on the part of large contractors. Unions should include all workers on a plantation unit who are not aligned with management of the plantation, though this plan might have to be changed to prevent formation of company unions. There should be the closest liaison among plantation units in each county. Subsidiary units among members of the same nationality might be advantageous. This is Sen Kateyama's idea, but probably would have to be used with caution because of the danger of nationalities deserting each other. Also, the minor nationalities would be unprovided for. 2. Lesser industries should be organized, with no distinction among nationalities, thus breaking down the present wage division between whites and Orientals in the building trades, etc. The special attention should be paid to exploitation by fellow Oriental contractors and storekeepers. The coffee growers of Kona should be organized into cooperatives to try and break the power of the factors. By organization of trade unions, public opinion off the plantation could partially be built up favorable to a militant plantation organization. Subsidiary organizations should be built up in industries subsidiary to pineapple and sugar, the Honolulu Iron Works, the railways, the inter-island, the trucking service. These are necessary to help win major strikes and to build up supporting morale. 3. To secure unionization, an intensive campaign of propaganda will be necessary for some while. It must be directed toward bringing workers and prospective workers of all races to see that their economic interests are identical, and that any advances must be won from the sugar pine baronage. Leadership must be developed among the young Americans already on the plantations, in the mills and canneries, and also from the Filipinos, and these leaders, citizens and Filipinos, must work from the start in the closest cooperation. It seems to the writer that Keichama's plan is weak in putting too much emphasis on national unions, necessary in other parts of the world that he knew, and in overlooking the citizen labor Filipino split in the cultural field. There is room for the widest diversity of national activities. In the economic field, none. The Filipinos can see clearly enough how they are discriminated against in favor of the Latin and Oriental workers, and probably will be willing to cooperate in any effort to better the lot of all workers if no racial distinctions are made. But the young Orientals, Latins, and Hawaiians will require the greatest pressure of propaganda and of the logic of events to make them see that their interests are the same as those of the despised alien. More lowly paid bayous, the present trend against alien labor must be redirected. Instead of hostility to the Filipinos, divide and rule of the sugar barons, there must be hostility toward the system which has imported foreign labor. The young Americans must be shown that only by bringing the Filipinos up to their own economic and social level can they be free from their competition. There is a wholly lower middle class hostile to the Oriental because of increasingly stiff competition, and hated by the latter because of the advantages with which they are credited. Wholly baiting, or indeed any form of racial hostility among the Radical Labor Party of Hawaii, will arouse even more difficulties than it will encounter anywhere, and would, in any case, be illogical and unfair. Every effort must be made to show both Howleys and others of the lower middle class that they stand in the same economic boat, and to persuade them to work together toward the same end. Overthrow of the power of the Big Five. Probably few Howleys except a few among the intelligentsia can be brought into the movement, but that does not detract from the logic of the position. If there is to be racial hatred, let it come from outside the movement. Therefore, radical labor must stand uncompromisingly against all forms of racial and intra-racial discrimination, for these divide and weaken labor by diverting its attention from its goals and making bad blood among its members. Here we have to thank the public schools for having made a good beginning which we must follow up. Examples: social exclusion of Filipinos, treatment of Itas and Okinawa Kenjin by fellow Japanese, preferential treatment of Howleys, Portuguese, and Hawaiians. 5. The youth of Hawaii are presently scarcely aware of the economic and political movements going on throughout the world. Every effort must be made to bring them to full class consciousness, to read understandingly and to see where they stand. Radical literature should be distributed, and a book stand should be established in Honolulu. Probably, as soon as possible, a newspaper should be established to express radical views. Close contacts between Hawaiian comrades and mainland centers should be established. Students going to the States should be contacted and propagandized on the mainland so that some, at least, will return more than mere satisfied dentists and doctors. 6. Goals acceptable to liberal as well as radical elements in Hawaii should be set up and striven for on the side as a means of arousing popular support. For example, anti-militarism. First, attack ROTC in the high schools and in the university. Attack kowtowing to the military in the local press and in public affairs. Weaken the National Guard as much as possible and propagandize its members to make them sympathetic to unions. Attack militarization of Boy Scouts. Education. Wide extension of educational opportunities. Removal of all fees and rentals. Aid of poor students. See Rex David's International Pamphlet No. 29, No Discrimination Racially in Placement of Teachers. It is highly important to win the teachers and university and high school students. Civil rights. Aim at legislation abolishing repressive legislation, present law against sedition, picketing, and curbing foreign press and legalizing strikes and picketing. Religion. As an immediate objective, take the Christian religion out of the public schools, showing how other religions are discriminated against in a subtle manner by the use of Christian prayers, Easter, Thanksgiving, and Christmas exercises, use of schools by Catholic priests, etc. Go on to attack Mission Board for its use of ministers to Humulamali plantation employees. Attack Roman Catholics for interference with public affairs, as in its attack upon the sterilization bill. Attack Buddhists for keeping up Japanese chauvinism. Attack exploitation of Mormons by LDS Church. Taxation, social legislation. Work for change in the incidence of taxation, outlining a complete program of social legislation to be agitated for. Press. Arouse the public to the danger of sugar-coated press. 7. This point I personally believe desirable, but I am not quite sure of its advisability. Organize a radical political party aiming to drive the Democrats and Republicans together and so expose their identity. Even one member in the legislature would give the workers of Hawaii a better chance for publicity and power than they have at present. Appendix D Statement of Essential Human Rights from the Annals of the American Law Institute. January 1946. Preamble. Upon the freedom of the individual depends the welfare of the people, the safety of the state, and the peace of the world. In society, complete freedom cannot be obtained. The liberties of the one are limited by the liberties of others, and the preservation of freedom requires the fulfillment by individuals of their duties as members of society. The function of the state is to promote conditions under which the individual can be most free, to express those freedoms to which every human being is entitled, and to assure that all shall live under a government of the people, by the people, for the people. This declaration is made. Article 1. Freedom of religion. Freedom of belief and of worship is the right of everyone. The state has the duty to protect this freedom. Article 2. Freedom of opinion. Freedom to form and hold opinions and to receive opinions and information is the right of everyone. The state has the duty to protect this freedom. Article 3. Freedom of speech. Freedom of expression is the right of everyone. The state has the duty to refrain from arbitrary limitation of this freedom and to prevent denial of reasonable access to channels of communication. Article 4. Freedom of assembly. Freedom to assemble peaceably with others is the right of everyone. The state has the duty to protect this freedom. Article 5. Freedom to form associations. Freedom to form with others associations of a political, economic, religious, social, cultural, or any other character for purposes not inconsistent with these articles is the right of everyone. The state has the duty to protect this freedom. Article 6. Freedom from wrongful interference. Freedom from unreasonable interference with his person, home, reputation, privacy, activities, and property is the right of everyone. The state has the duty to protect this freedom. Article 7. Fair trial. Everyone has the right to have their criminal and civil liabilities and their rights determined without undue delay by fair public trial by a competent tribunal before which they have had the opportunity for a full hearing. The state has the duty to maintain adequate tribunals and procedures to make this right effective. Article 8. Freedom from arbitrary detention. Everyone who is detained has the right to immediate judicial determination of the legality of their detention. The state has the duty to provide adequate procedures to make this right effective. Article 9. Retroactive laws. No one shall be convicted of a crime except for violations of law in effect at the time of the commission of the act charged as an offense, nor be subjected to a penalty greater than that applicable at the time of the commission of the offense. Article 10. Property rights. Everyone has the right to own property under general law. The state shall not deprive anyone of their property except for a public purpose and for just compensation. Article 11. Education. Everyone has the right to education. The state has the duty to require that every child within its jurisdiction receives education of a primary standard, maintain or ensure that there are maintained facilities for such education which are adequate and free, and to promote the development of facilities for further education which are adequate and effectively available to all its residents. Article 12. Work. Everyone has the right to work. The state has the duty to take such measures as may be necessary to ensure that all its residents have an opportunity for useful work. Article 13. Conditions of work. Everyone has the right to reasonable conditions of work. The state has the duty to take such measures as may be necessary to ensure reasonable wages, hours, and other working conditions. Article 14. Food and housing. Everyone has the right to adequate food and housing. The state has the duty to take such measures as may be necessary to ensure that all its residents have an opportunity to obtain these essentials. Article 15. Social Security. Everyone has the right to social security. The state has the duty to maintain or ensure that there are maintained comprehensive arrangements for the promotion of health, for the prevention of sickness and accidents, and the provision of medical care and of compensation for loss of livelihood. Article 16. Participation in government. Everyone has the right to take part in the government of his state. The state has the duty to conform to the will of the people as manifested by democratic elections. Article 17. Equal protection. Everyone has the right to protection against arbitrary discrimination in the provisions and application of the law because of race, religion, sex, or any other reason. Article 18. Limitations on exercise of rights. In the exercise of his rights, everyone is limited by the rights of others and by the just requirements of a democratic state. Appendix E. Statement to House Committee on Un-American Activities by Ring Lardner, Jr. October 1947. I do not wish to answer this question at this time for what seems to me to be cogent and compelling reasons. They are based on my conviction that the right to hold any political belief, including that of communism, carries with it as a natural corollary the right to choose for oneself the time and occasion to make a public statement of one's opinions. As the question stands now, if I am a member of the Communist Party, I would be exposing myself to the bigotry and inspired hysteria which is forcing not only the communists, but all left-of-center political groups into semi-secret status. More specifically, in view of the Motion Picture Association's blacklist statement, I would be banishing myself permanently from the profession in which I have earned my living since I was 21. If I am not a member, I would be exposing other men to the same bigotry and blacklist by contributing to the precedent that all non-communists must so declare themselves in order to isolate the actual offenders. I realize that much of the opposition to those of us who challenge the Thomas Committee's powers is based on the theory that communists are advocates of terror and violence or foreign agents or both, but the Supreme Court determined in the Schneiderman decision that this was not the case, and even if it has become so since, acts of treason must be uncovered and punished by due and orderly process of law. The communists declare themselves to be loyal Americans, and they propagandize in favor of democracy, tolerance, and higher living standards. Their critics say that they don't really believe in these things. I'm not trying to prove here which side of the argument is right. I simply maintain that it is not sound Americanism to prosecute or persecute people for what they think or what we think they think. Only an act can be a crime, never an idea. As Jefferson put it, it is time enough for the rightful purposes of civil government for its officers to interfere when principles break out into overt acts against peace and good order. I am withholding my answer at this moment, then, because I am in the middle of a fight for my right to keep silent about my political beliefs. Freedom of speech has no practical reality unless it includes the freedom to associate and to act in concert with others of a like mind, and the freedom to keep to himself those opinions and associations a man doesn't feel ready to communicate to his neighbors. Appendix F. Concurrent resolution requesting an investigation of communism in Hawaii by the U.S. House Committee on Un-American Activities, October 7, 1949. Concurrent resolution requesting the Committee on Un-American Activities of the House of Representatives of the Congress of the United States of America to investigate and report on un-American activities in the territory of Hawaii. Whereas, there have been numerous allegations and charges made by many groups and organizations both local and national in character, that there are subversive elements engaged in un-American activities within the territory of Hawaii, and whereas, most of such allegations and charges seem to have arisen from the report of the hearings before the Joint Committee on the Investigation of the Pearl Harbor Attack, Congress of the United States 79th Congress, hereinafter referred to as the Roberts Report, in which there were named a number of residents of the territory of Hawaii as being persons of subversive tendencies, many of whom have protested their innocence without avail, and whereas, one of the reasons for the opposition to statehood for Hawaii by some members of Congress of the United States of America is that Hawaii is under the control of these subversive elements or is in danger of such control should Hawaii become a state, and whereas, it is desirable that the Committee on Un-American Activities of the House of Representatives of the Congress of the United States of America conduct an immediate and impartial investigation on the scope of such alleged subversive element and activities within the territory of Hawaii, both in the interest of national defense as well as in fairness to Hawaii's aspirations for statehood, and whereas, the Committee on Un-American Activities of the House of Representatives of the Congress of the United States of America is an experienced body of great prestige and judicial character, well qualified and with sufficient power and facility to investigate the extent of such subversive activities within the territory of Hawaii. Now, therefore, be it resolved by the Senate of the 25th Legislature of the Territory of Hawaii, in special session, the House of Representatives concurring that the Committee of Un-American Activities of the House of Representatives of the Congress of the United States of America be, and it is hereby respectfully requested to conduct a full and thorough investigation of the alleged subversive elements and activities in the territory of Hawaii, and in connection with such investigation to provide an opportunity for the residents of the territory of Hawaii who have been charged in the said Roberts Report as having subversive tendencies to prove their innocence, and upon completion of such investigation to make a full report, and be it further resolved that certified copies of this concurrent resolution be forwarded to the President of the United States of America, to the Speaker of the House of Representatives of the Congress of the United States of America, to the Chairman of the Committee on Un-American Activities of the House of Representatives of the Congress of the United States of America, and to the Delegate to Congress from the Territory of Hawaii. Appendix G, Jr. 5. Creating the Territorial Subversive Activities Commission, J.R. 5. Joint resolution creating a fact-finding commission on communist and other subversive activities, including activities of persons seeking to overthrow our constitutional form of government by force and violence in the territory of Hawaii, conferring powers and duties upon it, and making appropriations. Whereas, in these times of grave international tension, there are within the United States communists and other subversive persons and groups which are presently and clearly endangering our domestic tranquility and unity, and our provision for common defense, who, under the cloak of the Constitution, seek to destroy our liberties and our freedom by force, threats, and sabotage, and to subject us to the domination of foreign powers, and whereas there are persons and groups motivated by contempt for our republican form of government and constitutional democracy and hatred of our insistence upon the inalienable rights of all men to life, liberty, and the pursuit of happiness, who are now seeking to achieve from within by subversion and conspiracy the substitution for these American ideals and processes a communist program of totalitarian government subservient to a foreign power or powers. And there is danger that the ordeal of war which we have endured in order to perpetuate our individual and collective freedom may be in vain, and whereas communists have been projecting their influence and their skillfully designed and adroitly executed propaganda into our national life and have extended their activities to the territory of Hawaii, and whereas there is evidence indicating that there are subversive persons and groups active in soliciting the support, confidence, and membership of persons in government who seek to further their purposes by corrupting and causing disloyalty in governmental offices and agencies, and whereas it is in the public interest that the problem as it affects the territory be studied with a view to the enactment of appropriate legislation, and whereas territorial legislation to meet the problem and to assist law enforcement officers can best be based on a thorough and impartial investigation by a competent and active commission appointed by the governor. Now, therefore, be it enacted by the legislature of the territory of Hawaii, Section 1. There is hereby created a fact-finding commission to be known as the Commission on Subversive Activities, hereinafter referred to as the Commission, for the purposes and with the powers and duties herein stated. The commission shall be composed of 7 members, 3 of whom shall respectively be residents of the islands of Kauai, Maui, and Hawaii, nominated and appointed for a term of 4 years by the governor by and with the advice and consent of the Senate of the territory of Hawaii, 1 of whom shall be designated in the appointment as chairman, and at least 3 of whom, including the chairman, shall be attorneys licensed to practice in all of the courts of the territory, and no more than 4 of whom shall be members of any one political party. Any vacancy occurring in the membership of the commission may be forthwith filled by the governor, and such appointment shall be effective at once. In case of the chairman's absence, illness, or incapacity, the said commission shall select from its membership an acting chairman to serve during such absence, illness, or incapacity. The chairman or acting chairman, as the case may be, shall 1. Preside at all meetings of the said commission, 2. Certify or authenticate all actions, doings, proceedings, or documents of the said commission, 3. Approve all vouchers for expenditure authorized by this joint resolution, 4. Hold in his custody, for the said commission, all records, papers, books, accounts, and other documents of the said commission, 5. Subject to the directions of the said commission, supervise all employees of the commission, and 6. Perform all other acts authorized by the said commission pursuant to the provisions of this joint resolution. Section 2. The Commission shall a. Investigate, ascertain, collate, appraise, study, and analyze all facts directly or indirectly relating to any person or persons or groups of persons within the territory who 1. Endanger the provision for the common defense against aggression by any foreign nation, 2. Seek to destroy by force, threats, or sabotage liberties and freedom guaranteed by or provided for in the United States Constitution, 3. Seek to subject the United States and the territory to the domination of any foreign nation. 4. Seek to achieve by subversion or conspiracy the substitution for American ideals and processes in the territory a communist or other program of totalitarian government subservient to a foreign nation. 5. To advocate the overthrow of the government of the United States or of the territory by force or violence or other unlawful means. 6. Seek to corrupt or subvert officers or employees of the government for the purpose of substituting for American ideals and processes in the territory a communist or other program of totalitarian government or for the purpose of overthrowing the government of the United States or of the territory by force or violence or other unlawful means. 7. Unlawfully engage in espionage or fifth column activities on behalf of any foreign nation. Or 8. Seek to undermine the stability of American institutions or individual rights, liberties, and freedoms, and b. Investigate, ascertain, study, and report on the activities of persons, groups, or organizations within the territory whose membership includes persons who are communists, or any other persons, groups or organizations, within the territory known or suspected to be dominated or controlled by a foreign nation or to have as an objective the overthrow of the governments of Hawaii or of the United States by force or violence or other unlawful means. Section 3. Reports to be made. The Commission may file interim reports to every special session of the Legislature of the Territory of Hawaii and file its final written report to the Legislature not later than the 10th legislative day of the next regular session, provided, however, the Commission may make a report to the Governor whenever circumstances in its judgment so warrant. Section 4. Powers and Duties. The Commission hereby created and exercising the powers and performing the functions vested in it by this resolution shall have all powers necessary or convenient to accomplish the objects and purposes of this resolution, including but not limited to the following duties and powers. 1. To employ, without regard to any residence qualifications provided for government officers and employees in other laws, and to fix the compensation of such clerical, investigative, legal, expert, and technical assistance as it may deem necessary, which assistance shall not be subject to the territorial civil service and classification laws. 2. To create committees from its membership and to designate the chairman thereof, assigning to the committee any study, inquiry, investigation, or hearing which the Commission itself has authority to undertake or hold, and the committee shall have and exercise all of the powers conferred upon the Commission, limited by the express terms of the resolution or resolutions of the latter defining the powers and duties of the committees, which powers may be withdrawn or terminated at any time by the Commission, provided that no report of a committee shall be made public until and unless it is adopted and released by the Commission. 3. To adopt, and from time to time, amend or revise rules as may be necessary or desirable to govern its procedure, including the fixing of its own quorum and the number of votes necessary to take action on any matter. 4. To contract with such other agencies, public or private, within or without the territory, as it deems necessary for the rendition and affording of such services, facilities, studies, and reports to the Commission as will best assist it to carry out the purposes for which it is created, and to lease, rent, or buy such supplies and facilities as may be required. 5. To make a complete study, survey, and investigation of every phase of the subject of this resolution, including but not limited to the operation, effect, administration, enforcement, needed revision and enactment of any and all laws in any wise bearing upon or relating to the subject of this resolution. 6. To meet at any and all places in this territory, in public or executive session. 7. To report its findings and recommendations to the Legislature or to the Governor from time to time and at any time, except that the final report shall be filed not later than is herein provided, and provided that no such report shall be released to the public except with the prior approval of the Governor or the Legislature, and 8. To do any and all other things necessary or convenient to enable it fully and adequately to exercise its powers, perform its duties, and accomplish the objects and purposes of this joint resolution. Section 5. The Commission shall adopt proper rules to provide, that the subject of any investigation be set forth clearly in advance to witnesses called, b. That witnesses will have the right to be accompanied by counsel, permitted to advise the witness while on the stand of his rights. c. That witnesses may be permitted a reasonable opportunity at the conclusion of the examination by the Commission to supplement their testimony in writing on matters with regard to which they have been previously examined. d. That witnesses will be permitted to inspect a stenographic record of their testimony, and, if the testimony is given at a public session, witnesses may receive a copy of their testimony at their expense. e. That no photographs, moving pictures, television or radio broadcasting of the proceedings shall be permitted while any witness is testifying. Section 6. Each member of the Commission, and any person designated by the Commission or by its chairman, is authorized and empowered to administer oaths. False swearing by any witness before the Commission or any committee thereof shall constitute perjury and shall be punished as such. Section 7. In the discharge of any duty imposed in this section, the Commission or any of its committees shall have the authority, through its designated members or subordinates, to issue subpoenas, compel witnesses to attend, and require the production of papers, books, accounts, documents, and testimony. The Commission may also cause the deposition of witnesses, residing either within or outside the territory, to be taken in the same manner as depositions in civil actions in the circuit courts. The Commission may pay fees and traveling expenses to ensure the witnesses' attendance if necessary. Furthermore, the Commission may procure, from any court having jurisdiction, a search warrant upon a complaint showing probable cause to believe that pertinent evidence is being concealed or withheld from the Commission or a committee thereof. In such a case, the Commission may cause a search to be made. If any person disobeys any subpoena issued in behalf of the Commission or any committee thereof, or refuses to testify to any matters before the Commission or any committee thereof, the Circuit Court of any circuit or the judge thereof shall, upon the application of the Commission, committee, or any of its members, compel obedience by proceedings for contempt as in the case of disobedience of the requirements of the subpoena issued from the court or a refusal to testify therein. Section 8. Every subpoena issued in accordance with Section 7 shall run in the name of the Territory of Hawaii and shall be sufficient if it A states whether the proceeding is before the Commission or a committee thereof. B is addressed to the person desired as a witness. C requires the person desired as a witness to attend at a certain time and place. And D is signed by the chairman of the Commission or the chairman of the committee before whom the person's attendance as a witness is desired. Every subpoena shall be served upon the person to whom it is addressed by the High Sheriff of the Territory or his deputy, a sheriff of a county or his deputy, any police officer, or any other person designated by the Commission to serve the subpoena. Section 9. Every department, commission, board, agency, officer, and employee of the Territory and any political subdivision thereof shall furnish the Commission and any committee, upon request, with all such assistance, information, records, and documents as the Commission or committee deems necessary for the accomplishment of the purposes for which the Commission was created. Any officer or employee of the Territory or any political subdivision thereof shall, upon written request of the Commission or any committee thereof, appear before the Commission or committee and provide evidence, information, or testimony as may be required. Section 10. Every witness who appears before the Commission, or any committee thereof, by its order, other than an officer or employee of the Territory or any political subdivision thereof, shall receive for his attendance the fees and mileage provided for witnesses in civil cases in the courts of record, and such fees and mileage shall be paid from the appropriation herein made for said Commission upon the presentation of proper vouchers sworn to by such witness and approved by the chairman of said Commission. Provided, however, that in the case of expert witnesses, the Commission may pay such additional amounts as it deems proper in the circumstances. Section 11. No person shall be excused from attending and testifying or from producing books, papers, or documents before the Commission or any committee thereof in obedience to the subpoena of the Commission or of any committee thereof. But no individual shall be prosecuted or subjected to any penalty or forfeiture on account of any transaction, matter, or thing concerning which he is compelled, after having claimed his privilege against self-incrimination, to testify or to produce evidence, documentary or otherwise, except that any individual so testifying shall not be exempt from prosecution and punishment for perjury committed in so testifying. Section 12. The members appointed to the Fact-Finding Commission on Communist Activities in the Territory of Hawaii shall be reimbursed for their actual traveling and hotel expenses incurred by them while attending sessions of the Commission or any committee thereof at any time or times during the lawful existence of the Commission and in the performance of any individual duty required of them by the Commission. The same to be paid upon their individual vouchers, approved by the chairman of the Commission, from such funds as may be made available therefor. The salaries and expenses of any expert, clerical, investigative, legal, technical, and other assistants employed by the Commission, and all other proper costs, charges, and expenses incurred by the Commission shall be paid upon vouchers approved by the chairman of the Commission from such funds. Section 13. There is hereby appropriated from the general revenues of the Territory for the purpose of defraying the expenses of the Commission, the sum of $75,000, $75 million, or so much thereof as may be necessary, said funds to be paid out of the Treasury of the Territory on vouchers as herein provided on the warrant of the Auditor of the Territory. Section 14. If any phrase, clause, sentence, subsection, section, provision, or part of this joint resolution, or its application to any person or circumstances, is for any reason held to be unconstitutional or invalid, the remaining portions of this joint resolution, or the application of this joint resolution to other persons or circumstances shall not be affected, and such remaining portions of this joint resolution shall remain in full force and effect thereafter. The legislature hereby declares that it would have passed this joint resolution, and each phrase, clause, sentence, subsection, section, provision, or part thereof, irrespective of the fact that any one or more of the phrases, clauses, sentences, subsections, sections, provisions, or parts be declared unconstitutional or invalid. Section 15. This joint resolution shall take effect upon its approval. Approved October 26, 1949. HJR LJR 5. Appendix H, Motion to Quash Service by Subpoena. Before the Committee on Un-American Activities of the House of Representatives of the United States, April 1950. Now comes the witness above named by his attorney and moves to quash the service of the subpoena directing the witness to appear before the Committee on Un-American Activities of the House of Representatives of the United States on the following grounds. The committee's utilization of congressional power as an agency of government to compel disclosure of private political opinion and association is forbidden in that a. It interferes with, obstructs, coerces, and abridges the exercise of the rights and duties of political expression through speech, assembly, association, and petition, in contravention of the First Amendment to the Constitution of the United States. B. It deprives the witness of the right to privacy and silence in such matters in contravention of the Fourth and Fifth Amendments to the Constitution of the United States. C. It interferes with, obstructs, coerces, and abridges the exercise of the governmental powers reserved to the people of the United States in contravention of the Ninth and Tenth Amendments to the Constitution of the United States. 2. The statute creating the House Committee on Un-American Activities on its face and particularly as construed and applied is unconstitutional in that a. It permits investigation of, and as construed and applied has been used to investigate, the content of speech and ideas, an area in which no legislation is possible, thereby exceeding the boundaries of legislative power under Article I of the Constitution of the United States. B. It permits the process of investigation to be used, and as generally construed and applied it has been used, to expose and stigmatize the content of any and all speech and ideas disapproved by the members of the committee, thereby impeding and placing a burden upon free thought, speech, and association in violation of the First, Ninth, and Tenth Amendments to the Constitution of the United States. C. It deprives witnesses of property rights without due process of law in contravention of the Fifth and 14th Amendments to the Constitution of the United States. D. It seeks to compel witnesses to testify against themselves in contravention of the Fifth Amendment to the Constitution of the United States. Wherefore the witness prays that this motion to quash said subpoena be granted. Appendix J, News Release FEBRU in Pesos 1951, by Jack Kawano, former president of ILWU Local 137, all during the latter part of 1949 and in 1950, and even up to the present time, I have been approached on many occasions by members of the ILWU and asked the following questions. 1. Are you an organizer for the CIO? 2. Are you a communist? 3. Have you ever been a communist? These questions have been constantly on my mind because, as many of the ILWU members know, I pioneered the organization of the Waterfront Union which, in turn, sparked the organizational drive among workers in the sugar industry, which became the backbone of the ILWU in Hawaii. Because of this, I knew that someday I should publicly answer these questions. Now that the contempt case against me is cleared, I feel I am able to make my personal position clear to all those who may be interested, without fear of intimidation or coercion from any source. I wish all to know that I am not an organizer for the CIO. My position is that in the event anyone tried to split the ILWU by raids or otherwise I would help in whatever way I could to maintain unity within the membership of the ILWU. I am not a communist. However, I was a member of the Communist Party. I joined the Communist Party because some individual communists were willing to assist me in organizing the Waterfront Union. The waterfront employers were totally intolerant of labor unions. They did all they could to smash all attempts to organize the waterfront. No civic or community organizations showed any signs of willingness to assist in our organizing efforts. I did not think it was harmful to the union as long as the communists were willing to assist me in bringing up the living standards of the workingmen because they led me to believe that the basic existence of the Communist Party was primarily to promote the best interests of the workingmen. I decided to quit the Communist Party because I found that the primary existence of the Communist Party was not for the best interests of the workingmen but to dupe the members of the union, to control the union, and to use the union for purposes other than strictly trade union matters. The communists play rings around the rank and file members of the union and their union's constitutions, by meeting separately and secretly among themselves and making prior decisions on all important union policy matters, such as the question of strikes, election of officers, ratification of union agreements, the question of American foreign policy, and all other important matters of the union. Primarily, all of these decisions are made on the basis of what is good for the Communist Party and not what is good for the membership of the union. For instance, in the election of officers of the Sugar Local in 1946, the Communist Party met and made their decision, which was to get their candidate elected at all cost. As a result of this decision, I was informed that the Communists stuffed the ballot box on behalf of their candidate. Another instance was the proposed sugar strike of 1949 at the time when the longshore strike was on. The Communist Party had met and made a decision to pull the workers in the sugar industry out on strike. Had they been able to call out the sugar workers on strike at that time, when the longshoremen were having a life and death struggle in their strike against the waterfront employers, the strike for both the longshoremen and the sugar workers would have been smashed. There is no real local autonomy as long as the rank and file members allow the Communist Party, through the few communists and their union, to predetermine all important matters on union policy and dominate their union. Today, I am more than ever convinced that I did right by quitting the Communist Party. In view of the international situation, when our boys are giving their lives to their country, which is at war with Communist Korea and China, I cannot help but believe that anyone who is a communist and is willing to assist Communist Korea, China, or any other communist nation today is dangerously flirting with treason against his own country. For the sake of the Union, I call on you to check on what I have said. It is your duty to investigate, to ask pointed questions to get information. When you have done so, you will find the destructive effects of communism within the Union. I strongly urge the rank and file members of the ILWU, every one of them, to fight to keep the control and management of their union and union activities in the hands of the rank and file members. To accomplish this important task, all communists and those who follow the communist line should be rejected by the rank and file membership. Appendix K, Letter to Delegates, Honolulu, TH, April 5, 1951. To Convention Delegates 9th Biennial ILWU Convention Honolulu, TH. Dear friends, allow me to take this opportunity to extend my aloha to you convention delegates. I sincerely hope that your convention will be successful and will result in further strengthening the ILWU. I believe one of the problems facing this convention is to clarify the policy of the ILWU with regard to the right of the individual to testify or not to testify before un-American activity committees. I wanted to testify at the last hearing, but I was advised by the officers of the ILWU, including its attorney, not to testify, so I followed their advice and did not testify before the un-American activities committee hearing. Later, I realized that I made a mistake. My thinking here is based on 2 points. 1. In view of the world situation, where our country is at war with communist forces in Korea, I cannot see myself assisting communists or communism in any way, particularly when you consider them to be enemies of our country. Therefore, I feel I owe it to my country to bring to light all I know about communist activities in Hawaii. 2. While I participated as a communist in the ILWU, predetermining its policies from time to time, I realized that each time I engaged in such activities, I was undermining and violating the policies and principles set forth in the Constitution of the ILWU, as clarified by Resolution No. 11 adopted on January 27, 1951, attached to the resolution on red baiting entitled Statement of Principles adopted at the Territorial Sugar Unity Conference held in Hilo, Hawaii, January 3, 4, 5, 194. The third paragraph of the statement reads as follows. The ILWU is governed by the principles and policies formulated through the democratic machinery of the Union. No political party, communist, Republican, Democratic, or other, and no racial or religious group shall determine our policies. Around the latter part of July or early August 1950, when the Un-American Activities Committee investigator came back to Hawaii, I wanted to testify in order to clear myself, both with my country and also with the Union. I told Regional Director Jack Hall of my opinion and intentions. However, he made it very clear to me that if I testified, I would be regarded as a union breaker, also that I would be regarded as a rat by the entire membership of the ILWU and that my name would be mud from that time on. I told him that by testifying, I would be helping the Union because through it, I would be able to bring to the attention of the ILWU those that are predetermining policy of the Union and that, therefore, are violating the principles and policies of the ILWU as set forth in its Constitution. Therefore, I considered it my duty to bring this to the attention of the Union. Hall insisted that that was ratting. I disagreed with him and gave the following example as an argument. If my union is out on strike, and I knew of some of the members scabbing on our strike, I certainly would consider it my duty to bring this to the attention of the striking membership, and by doing that I do not consider myself a rat. On the contrary, I would consider myself a good union member by bringing it to the attention of the Union. And the same thing goes when someone or a group of individuals is violating the Constitution of the Union. I had similar conversations not only with Hall but also with McElrath and Arena, but they all ended up the same way. You will break the Union, we will call you a cat in the ILWU, and your name will be mud. So, that time again, I did not testify. At that same time, Hull offered me a job with the ILWU. I told him that I would gladly accept the job provided he agreed to allow me two privileges. 1. That I be allowed to testify. 2. That I don't have to take dictation from the Communist Party. The offer was withdrawn promptly. As time went on, I became more and more convinced that I did wrong by not testifying. And so on February 10, 1951, I made my position clear to the membership of the Union and to the public. A copy of that statement is attached herewith. Although I am not a member of the ILWU at this time, I am still a Union man at heart. Any man who gives 15 of his best years to the labor movement, 7 of which spent organizing without compensation while being unemployed, cannot simply wipe off his memories and Union habits and sentiments overnight. Therefore, I am very much interested in the policy of the ILWU. There is no question that the ILWU's policy is to support those witnesses who refuse to testify at the hearing. Is it also the policy of the ILWU to guarantee to its members the right to testify at any such hearings if that happens to be their convictions? For the benefit of the membership of the Union, and in order to further strengthen the ILWU, I feel it is important for the policy of the ILWU to be clarified not only for the benefit of the Communists, who I believe have a right to belong to the Union as long as they do not violate the Constitution of the Union, but also for the individuals who disagree with communism, know its operation in the ILWU, where they are predetermining policies for the ILWU, and want to bring this to the attention of the membership, but cannot do this because the policy of the ILWU does not seem to support them in their position, and because the officers of the Union particularly discourage it. Therefore, I strongly urge that the ILWU convention go on record guaranteeing the right of the individuals to follow their convictions, be it refusing or not refusing to testify before any committee, governmental or union, which has authority to investigate communism. Fraternally yours, Jack H. Kawano. Appendix L. Indictment. The grand jury charges. 1 from on or about April 1, 1945, and continuously thereafter up to and including the date of the filing of this indictment, in the District of Hawaii, within the jurisdiction of this court, and elsewhere, Charles Kazuyuki Fujimoto, Dwight James Freeman, Jack Wayne Hall, Eileen Toshiko Fujimoto, Jack Danishi Komodo, John Ernest Rieneki, and Koji Ariyoshi, the defendants herein, unlawfully, willfully, and knowingly did conspire with each other and with William Z. Foster, Eugene Dennis, John B. Williamson, Jacob Stachel, Robert G. Thompson, Benjamin J. Davis, Jr., Henry Winston, John Gates, Irving Potash, Gilbert Green, Carl Winter, Gus Hall, and William Schneiderman, co-conspirators but not defendants herein, and with divers other persons to the grand jury unknown, to commit offenses against the United States prohibited by Section 2 of the Smith Act, 54 Stat. 671, 18 U.S.C. 10, and 18 U.S.C. by so conspiring, 1 unlawfully, willfully, and knowingly to advocate and teach the duty and necessity of overthrowing the government of the United States by force and violence, and 2 unlawfully, willfully, and knowingly to organize and help organize as the Communist Party of the United States of America a society, group, and assembly of persons who teach and advocate the overthrow and destruction of the government of the United States by force and violence. 2. It was part of said conspiracy that said defendants and co-conspirators would become members, officers, and functionaries of said party, knowing the purposes of the party and in such capacities would assume leadership in said party and responsibility for carrying out its policies and activities up to and including the date of the filing of this indictment. 3. It was further a part of said conspiracy that said defendants and co-conspirators would cause to be organized groups, cells, clubs, sections, county, district, and state units of said party in the territory of Hawaii and elsewhere, and would recruit and encourage recruitment of members of industries and plants. 4. It was further a part of said conspiracy that said defendants and co-conspirators would publish and circulate and cause to be published and circulated books, articles, magazines, and newspapers teaching and advocating the duty and necessity of overthrowing and destroying the government of the United States by force and violence. 5. It was further a part of said conspiracy that said defendants and co-conspirators would write and cause to be written articles and directives in publications of the Communist Party of the United States of America, including, but not limited to, Political Affairs, Hawaii Star, Honolulu Record, Daily People's World, Daily Worker, and The Worker, teaching and advocating the necessity of overthrowing and destroying the government of the United States by force and violence. 6. It was further a part of said conspiracy that said defendants and co-conspirators would conduct and cause to be conducted schools, classes, meetings, and discussion groups for the indoctrination of recruits and members of said party in the principles of Marxism-Leninism, in which would be taught and advocated the duty and necessity of overthrowing and destroying the government of the United States by force and violence as speedily as circumstances permit. 7. It was further a part of said conspiracy that said defendants and co-conspirators would agree upon and carry into effect detailed plans for the vital parts of the Communist Party of the United States of America to go underground in the event of emergency, and from said underground position to continue in all respects the conspiracy described in paragraph 1. 8. It was further a part of said conspiracy that said defendants and co-conspirators would use false names, passports, and other false documents in order to conceal their identities and activities as members and functionaries of said party. 9. It was further a part of said conspiracy that said defendants and co-conspirators would do other and further things to conceal the existence and operations of said conspiracy, in pursuance of said conspiracy and to effect the objects thereof, in the District of Hawaii and elsewhere. The defendants and co-conspirators did commit, among others, the following overt acts. 1. Charles Kazuyuki Fujimoto, Jack Wayne Hall, Eileen Toshiko Fujimoto, Jack Denishi Komodo, and John Ernest Rieneki, defendants herein, did attend and participate in the 1946 convention of the Communist Party of Hawaii, held at Kano, in the city and county of Honolulu, territory of Hawaii. 2. From the aforesaid 1946 convention of the Communist Party of Hawaii until the 1947 convention of the Communist Party of Hawaii, Charles Kazuyuki Fujimoto, Jack Wayne Hall, Eileen Toshiko Fujimoto, Jack Denishi Komodo, and John Ernest Rieneki, defendants herein, did continuously serve and act as members of the Executive Board of the Communist Party of Hawaii. 3. Charles Kazuyuki Fujimoto, Dwight James Freeman, Jack Wayne Hall, Eileen Toshiko Fujimoto, and John Ernest Rieneki, defendants herein, did attend and participate in the 1947 convention of the Communist Party of Hawaii, held at Kano, in the city and county of Honolulu, territory of Hawaii. 4. From the aforesaid 1947 convention of the Communist Party of Hawaii until the 1948 convention of the Communist Party of Hawaii, Charles Kazuyuki Fujimoto, Dwight James Freeman, Jack Wayne Hall, Eileen Toshiko Fujimoto, and Jack Denishi Komodo, defendants herein, did continuously serve and act as members of the Executive Board of the Communist Party of Hawaii. 5. Charles Kazuyuki Fujimoto, Dwight James Freeman, Jack Wayne Hall, Eileen Toshiko Fujimoto, Jack Denishi Komodo, John Ernest Rieneki, and Koji Ariyoshi, defendants herein, did attend and participate in the 1948 convention of the Communist Party of Hawaii, held at Kano, in the city and county of Honolulu, territory of Hawaii. 6. From the aforesaid 1948 convention of the Communist Party of Hawaii until the date of this indictment, Charles Kazuyuki Fujimoto, Dwight James Freeman, Jack Wayne Hall, Eileen Toshiko Fujimoto, Jack Denishi Komodo, John Ernest Rieneki, and Koji Ariyoshi, defendants herein, did continuously serve and act as members of the Executive Board of the Communist Party of Hawaii. 7. On or about October 18, 1948, Charles Kazuyuki Fujimoto, a defendant herein, did announce his position as chairman of the Communist Party in Hawaii. 8. On or about October 21, 1948, Koji Ariyoshi, a defendant herein, did publish and circulate and cause to be published and circulated an issue of the Honolulu Record. 9. On or about January 12, 1949, Jack Wayne Hall, a defendant herein, did travel from the city and county of Honolulu, territory of Hawaii, to the city of San Francisco, California. 10. On or about June 3, 1949, Charles Kazuyuki Fujimoto, Dwight James Freeman, Eileen Toshiko Fujimoto, Jack Denishi Komodo, John Ernest Rieneki, and Koji Ariyoshi, defendants herein, did attend and participate in a meeting held at 2162 Makanani Drive, city and county of Honolulu, territory of Hawaii. 11. On or about April 1, 1950, Jack Wayne Hall, a defendant herein, did instruct a person whom the said Jack Wayne Hall believed would be subpoenaed as a witness before a committee of the Congress of the United States, in violation of Section 3 of the Smith Act, 54 Stat. 671, 18 U.S.C. 2 and 18 U.S.C. 371, dated at Honolulu, th. this 29th day of August, 1951.